This is WAAY 31 Law Call.
Good evening and welcome to WAAY 31 Law Call. I'm Sharon Doviat. Tonight we're taking calls and questions about DUI law, driving under the influence, and that can be under the influence of alcohol or under the influence of illegal substances or under the influence of even medication that you shouldn't be driving with if it affects your driving. The 31 Law Call number to call in your questions, 256-536-0077. You can also email a question. You can email a question to Law Call. Any question on any legal subject any day of the week, you send it to lawcall@waaytv.com. And when we get to a show that's on point, we will pull out some of those. And we have some of your email questions tonight. Getting us started tonight, Michael Timberlake's here from Timberlake & Lee. Good to have you here.
It's great to be here.
We have got some video. We always like to start off the show with the You Make the Law Call video. We pull these from YouTube. Take a look at this one. So, you know, a typical day on the interstate. Okay, this guy.
Ooh,
is he drinking and driving? It gets worse. Hold on.
He missed it. Oh.
Hold on. Okay. It's hard. I mean, we don't know whether this is a drunk driver, but when something like this happens, you know, you guys do personal injury cases. What do we need to be thinking about? Of course, you get everybody out of the vehicles, but from a legal standpoint, what do you need to be considering here?
You know, I mean, obviously, clearly he's trying to, you know, take that turn at a way too high rate of speed, or he's distracted, or he's, you know, obviously intoxicated, you know, and then that leads to catastrophic, you know, claim. You know, collision between the truck and the other vehicle. You know, the white car, you know, you can't do this. You know, it's not acceptable behavior. If you are, you know, under the influence of alcohol, it changes kind of the dynamic in a case that we're dealing with because you take from somebody that's just made a careless mistake or was what we call negligent into a realm of, you know, whether it's, you know, intentional conduct or wanton conduct, which means that you knew that this was going to happen or could happen and you engaged in that conduct anyway. And that turns into a case where you can get the standard compensatory damages as well as what we call punitive damages, which are designed to punish a wrongdoer for their conduct. So it adds another layer of damages, and it can be quite significant if you can prove that you know, that somebody was under the influence, and that's you know relatively easy to prove in this type of situation.
Yeah. Okay, tonight we're answering calls and questions about DUI law, and you brought with you a great expert.
Right, absolutely. We brought our friend Justin Michael. He's coming over from the Shoals of the Quad Cities here, and he's got a general practice over there. He does a lot of this type of work, and we're very happy to have him.
Thank you for having me.
And one of the things that we were talking about before the show, Justin, we were talking about time limits, and sometimes people don't realize that they need to be considering time limits when they've got a DUI case, that they don't need to wait around about hiring a lawyer.
No, that's especially true if they can get in the first 10 days. There's a thing called an administrative suspension that happens if someone, if they take the breathalyzer and it's 0.08 or higher, then they get an administrative suspension of their driver's license. Well, they've only got 10 days to request an administrative hearing of that. And if they're able to do that, then sometimes they're able to keep their driver's license during the time that when ordinarily it would be suspended administratively. And that suspension is separate than the criminal penalty. There's two different ways that they can have their licenses suspended.
So don't wait around before going to see somebody.
Yeah, I mean, if you just get arrested for DUI, if you have a positive test, they're going to suspend your license for, you know, until that's adjudicated. So being able to have your driver's license during the time period that you're, you know, trying to work out your case or your case is being litigated is a huge advantage.
We got in this email question from Jeremy, and let's throw this one out here. Jeremy said, I was pulled over and charged with DUI, but the officer said the reason he pulled me over is because I had a tail light out. Well, it turns out that wasn't true, so can I challenge my arrest based on that? What do you think about that one, Justin? Can he challenge based on that?
I think his lawyer should challenge it based on that. There's the Fourth Amendment protects against unreasonable searches and seizures, and whenever someone's stopped by a police officer, they are seized. Fourth Amendment protects against violations against people's personal freedoms, and the issue is going to be if it was objectively reasonable. And so they've got to have an actual violation of the law before the stop is reasonable. In 2014, the U.S. Supreme Court decided a case from North Carolina where a guy had one brake light that didn't work. And the law was about as clear as mud as to whether they were required to have one light or two lights, or whether every piece of equipment was supposed to be working. And so it was objectively reasonable there for the officer to have pulled him over, because anybody could have read the law to be this or could have read it to be the other way. So it's not clear from the email if you had one working taillight or only one or two. But Alabama law is fairly clear. It says every motor vehicle trailer shall be equipped with at least one tail lamp mounted on the rear, which when lighted as required emits a red light plainly visible from a distance of 500 feet to the rear. So Alabama's law is very clear on that, and you just have to have at least one. So if you had a taillight working, the officer made a mistake on stopping you, then everything the officer learned from the stop should be excluded from evidence.
Worth challenging.
Yeah, absolutely. A police officer they can't come up and pull you over for a pretense. They have to have a legitimate reason to stop you, to pull you over. Now, the most common thing you see is, you were swerving, or you changed lanes, or moved in and out of lane. Sometimes that's hard to objectively defend against, but if they pull you over for not having brake lights, and you have brake lights, that's clearly objective. That's something that you could use to defeat the arrest.
We've got callers waiting. We've got Blake on the line with a question from Florence. Hi, Blake. Thanks for calling. What's your question tonight?
Yes. I was just out of curiosity. I have a sleep disorder,
okay,
and I'm prescribed Klonopin, and I was previously prescribed Ambien. I have a really, really bad sleep disorder. And I was just curious as to, say the next morning I was out and about, or even at lunchtime the next day, and were to be involved in an accident, would that show up like I was driving under the influence?
And could you get a DUI being on those kind of medications?
Yeah, that's a good question. It's not just
alcohol.
alcohol.
I do not drink alcohol at all.
Right.
Okay.
I'm a drinker.
But Justin, it's not just alcohol, right?
No, there are 5 different ways that people can be charged for DUI. There's one is under the influence of alcohol. The other ones, if they're at 0.08 or above, then alcohol and medications interacting. And then just any kind of a controlled substance DUI, or any kind of a foreign substance in the body. Typically with prescription medications, you're going to have a warning label that says, be careful when driving with alcohol, and don't drive until you're familiar with the effects of the medication. So if you switch medications, it could be a problem. And yes, if it's depending on how the effects of the medication are, it could be a problem for you.
Because just because a doctor prescribes something for you doesn't mean that you can drive or do anything, right? They might give you painkillers and you're loopy as can be.
If you're intoxicated, you can't drive. I think one of the things in law enforcement that they've had for a long time is the difficulty trying to prove the quantities of what other kind of if it's medication or if it's some kind of recreational drugs. Proving that has been very difficult for law enforcement unless you have a blood test, and still then, quantities are very important in terms of that situation. The law is clear with regard to alcohol, but other intoxicants, it's been a little bit different. But they're working on that in terms of the different type of machines that they can do to quantify and test for recreational drugs.
We've got Richard on the line with a question from Maysville. Hi, Richard. Thanks for calling. What's your question tonight?
My question is that about 2 years ago, I moved down here from Chicago.
Okay.
And I bought a house over here in Maysville. Well, I was coming to not Terre Haute, but Fayetteville. And a buddy of mine had a motorcycle shop up, and he goes, man, whenever you come down through there, you got to watch it, because the heat is pretty bad, and I wasn't paying attention. Well, I got pulled over, and they sent me, told me I could go to court on this one day or pay the ticket, and I went ahead and I paid the ticket because I was guilty. I was in a 65. I was running like an 80.
Okay.
And I went ahead and paid it. How long does that stay on your record? Or does it stay on your record forever?
And you're just talking about a regular old speeding ticket, right? Not a DUI kind of ticket. Yeah.
I'm 65 years old, and it's the first one I had since I was about 17.
Good job.
Right,
Knock on
right.
wood. Yes.
Yeah,
Okay.
now, Justin, I know they have a point system that you can accumulate a certain number of points before they terminate your license or they suspend your license, but I don't know what the time frame is.
With that, I'm not sure. It could be anything. You could talk to an attorney about having it expunged. Certain types of offenses can be expunged, and you probably need to talk to an attorney specialist about that. Now, whether your insurance company is going to be able to see that and keep your rates up, that's to be determined. If you don't have a commercial driver's license or anything, I don't know really who's going to be looking at your record. Why you'd be too concerned about that, other than maybe insurance reasons, unless you just want to clean up the one mistake that you had. And if that's the case, I'd recommend you talk to an attorney about expunging it.
Okay. You're telling us take a break. We're going to take a break. Be right back talking about driving under the influence, DUI. Stay with us.
You're watching WAAY 31 Law Call, where lawyers come to help. Your rights, your calls, live. Hosted by family law attorney Sharon Dovian. With the personal injury attorneys of one of the Valley's most respected law firms, Timberlake and League. Featuring the knowledge of managing partner Michael Timberlake, with millions of dollars awarded to his clients. And the experience of attorney Will League, a strong courtroom fighter known for his commitment to winning. And the fellow partners of Timberlake and League Heath Brooks and William Meservey. This is WAAY 31 Law Call.
Welcome back to 31 Law Call. We've got with us Michael Timberlake from Timberlake and League. They are personal injury attorneys and do everything from car accidents to medical malpractice. We've got with us Justin Michael, who is an attorney from over in Lauderdale County. He does felonies, he does DUIs, he does personal injury cases and workers' comp. If we put you guys together, we've got Justin Timberlake. So we just got a little celebrity there. It's fun,
We'll be good.
Fun to have everybody tonight. I wanted to ask Justin about field sobriety test. Okay. Do you encourage people or discourage people from taking field sobriety tests? You know, those walk and turn tests, and can you even say no to a police officer?
Yes, they're voluntary. If typically when someone stopped, if they get to the point where the officers ask them to get out of the vehicle and to perform any test, the officer's probably made up his mind, and he's just trying to get more information. So the standard field sobriety tests, where you're going to walk and turn, stand on a leg, the officer's just trying to build his credibility for having reasonable suspicion, and you can politely decline those. But if you get to that point, then usually the officer's already made up their mind anyway.
Gotcha.
Yeah, you're just, at some point you're just creating more evidence to try to allow them to convict you. So you need to keep that in mind.
And sometimes they'll do these things where they make you count backward or do your ABCs backward or something. And I don't, in the middle of the night, surprised and doing a test, I don't know how many of us could do that. We've got callers waiting. We've got Dave on the line with a question from Huntsville. Hi, Dave. Thanks for calling. What's your question tonight?
My question is, if someone is pulled over by, of course, the police officers, and they went ahead and took the field sobriety test and the breathalyzer, what is the option as far as when the police officers have taken you to jail, even though you passed the other test, at his discretion, and you go to jail, it costs you all this money. No offense, you guys, attorneys, but
that's okay.
You guys help us, get out of some things at times when we need help. So, however, what can you do, or is there any options as far as contacting the police department's internal affairs and going after the officer as far as recovering what they cost you as far as the fees and fines and, attorney's fees, so on.
Yeah, so you've gone through the whole process, you've been found not guilty, right? Is that what
Yes.
happened, Dave? And you
Yes,
feel
ma'am.
like they wrongly charged you. Can
Yeah.
you
Right.
can you do something about that?
Well, you don't really have a cause of action for negligent, prosecution. If you can prove that the officer was malicious in what he did, and that he knew or should have known that what he was doing was wrong, and that you are not likely to be found guilty, then you could potentially have a claim. But that's a very, very high burden of evidence to prove. And so just in the normal case where, if the evidence shows not necessarily that you were guilty, but there was probable cause to believe that you were guilty, that allows the officer to, conduct the search, which would, lead to an arrest, which would, allow you to, be convicted, or, not convicted, just depending upon what the evidence is. The preliminary thing they do in DUIs is they'll either do a field sobriety test or do, a breathalyzer test, or just based upon the officer's, impression of what's going on, they can arrest you. Then you have to go, once they arrest you, then you can opt in or out of taking a chemical analysis. It's a Draeger test, basically. It's a breath test, but it's much more sophisticated than a roadside test. Now, Justin, once you get to the station, do you have to take the Draeger test, the field sobriety, that test?
Alabama is an implied consent state, meaning that by driving on the roads, you have consented implicitly to take those tests. And if you refuse, you face consequences of automatic driver's license suspensions. You do have the option after the breath test, you can ask for a blood draw. And I've had clients that have one was a teetotaler, no drugs, no alcohol ever. And it was only by requesting that the blood test, that proved that there was nothing intoxicating in their system, that they're able to be adjudicated not guilty.
And it should not be that you're proving your innocence. That's
Right,
not
right.
the way the system is supposed to be, but that worked for your client, didn't it?
It absolutely did. And I recommend that anybody enforce their rights, especially and get the blood test.
Yeah, and unfortunately, going back to the caller, if the police officers do their job, they do it by protocol. There's no real way for you to go back and get your time, effort, and money back just because you were proven not guilty.
If you think there's a dirty cop, though, there are ways that you can report something like that to Internal Affairs. Yes, you can do that.
Absolutely.
But they're probably not going to pay your legal fees
and they're not going
back.
to pay your legal fees back.
Okay, we've got Joel on the line with a question from Hillsborough. Hi, Joel. Thanks for calling. What's your question tonight? Hey, Joel. Yeah. Yes, sir.
I got a felony DWI in Texas in 1998,
Okay.
and I moved to Alabama, and I was wondering, is there any way I could get that, completely, removed?
And your reason to want it removed is just what? You don't like having it on your record, or you're thinking if you got another DUI, would it jack up the punishment?
Well, I haven't got anything else.
Okay.
I've been clear.
Okay. So
Right,
since
right.
1998, that's a long time.
That is a long time, and I don't know, Justin may know, but I'm not familiar with the laws of Texas in terms of how to get things off your record. Some years ago, Alabama passed some laws to allow you to have, charges removed from your record. If you were declared to be not guilty, or they dismissed the charges, then you could petition to have that arrest removed from your record. And then just recently, in the past year or so, they have come up with another level of expungement that allows you to remove a misdemeanor conviction from your record, as long as it's a nonviolent conviction. So there are ways that states have done to kind of figure out how to remove things from the records based upon certain criteria. Justin, this is a felony conviction for DUI. In Alabama, that would not be something you could take off a record. I would not know about Texas.
No idea about Texas unless you can get a pardon somehow or get it dismissed. I wouldn't know how to do it in Alabama. Again, I could talk to those gentlemen. I recommend you talk to a lawyer about expungements.
Right.
And DUIs do fall off the counting system, right, over a period of time.
there's a look back period. Alabama used to have 5 years, but in 2018 it was extended to 10 years where they look back and you can get sentence enhancements. I'm not sure how a conviction from another state would play into that, but I believe there's typically, if you've ever had a felony conviction based on a DWI, then it would still count.
Gotcha.
Yeah, the more you're convicted of DWI in Alabama or DUI it's the punishment's much more severe. The first one's bad, but not that bad, but the second one's much worse, and the third one gets worse. So it really kind of compounds. So it's really something to be concerned about. Let's
talk a little bit about. Justin had told me that the older we get, the more likely we are to fail field sobriety tests, and that's very interesting. What are you seeing with those?
Well, you have the couple of tests that they do. The horizontal, it's called a horizontal gaze nystagmus test, and it's a test where the officer will ask you to look in a direction, and then he'll take a pen and he will move it outside of your field of view, and he'll watch your eyes track. Typically, people think that it's like an attention type test, and to see whether you follow directions, turn your head or not. But what they're actually looking for is how accurately your eye tracks. And there are 86 different types of nystagmus, and it is an optometrist test, and not one, unless the officer is a trained optometrist, I don't think is one that should be used with any type of certainty.
Yep. And the older we get, the more likely we are to fail things, right?
Especially with knees and that sort of thing.
Yeah. Walk and turn test and everything else.
Yes.
Okay, let's take a break. We'll be right back answering more of your questions all about DUI, driving under the influence. Stay with us. If you didn't get your questions answered tonight, here's how to get in touch with Justin Michael with the Michael Law Firm in Florence, 256-284-7471. Also check out michaelfirm.com. Here's how to get in touch with Michael Timberlake with Timberlake & League in Huntsville. They are personal injury attorneys, so everything from car crashes to medical malpractice. 256-536-0770 or 800-804-2502. The website is law-injury.com. And if you like them on Facebook, you learn more about the law that way, and they'll be on the midday show tomorrow answering questions.
Right, and Sharon does family law in Huntsville, and she does a great job with these things. Her phone number is 256-539-7337 or SharonFamilyLaw.com. If you've got questions about divorce, child custody, those types of things, give her a call.
In our last seconds, so if somebody's got a DUI case, but they also caused an accident and hurt somebody, do both of those cases go on? What happens?
Well, you can have a claim for both a civil remedy, which is for money damages, or a criminal remedy. The way the criminal case will affect a civil claim is that the civil case will be stayed. You can't prosecute your case until there's an adjudication in the criminal matter.
Okay. Thanks for all your calls and questions tonight. See you next week.